Thanks so much, Ned, for that really generous introduction. And at a risk of drawing things out further, I have to reciprocate the thanks to you and everybody at NYU who's made this such a pleasure for us to work on. It's really been wonderful, and it's great to work with somebody, Ned, who has such a great combination of knowledge and dedication and enthusiasm for this topic. So thank you very, very much. We're really looking forward to the discussion today. I'm not going to belabor or draw things out, except just a couple quick reminders. One, we are being taped and live streaming today. So if you're making your comments, keep that in mind. I think speakers, there may be forms for everybody to sign. If you haven't yet, please make sure you do that. Let me also thank all of you for being here. It is the mission of the Duke Center for Firearms Law to continue to deepen and broaden the scholarly conversation about firearms law. I think it's safe to say that discussion has gotten more interesting, more diverse, more nuanced over the years. We still have a long way to go, but I'm very proud of the progress that we've been able to make. And with that, I'm going to introduce the moderator of the first panel and then turn things over to him. Professor Vincent Southerland is Assistant Professor of Clinical Law, also the Director of the Criminal Defense and Reentry Clinic, and the Co-Faculty Director of the Center on Race, Inequality, and Law here at NYU. He was, before joining the faculty, an Assistant Federal Public Defender here in New York, and also worked for 7 years at the NAACP Legal Education and Defense Fund. So I will give it to him to introduce the panel. Again, thanks to all of you for being here. Professor Southerland.
Thanks so much. Good morning, everybody. I'm going to dive right in with really quick introductions, and then we'll get into our questions. We have an hour, so I want to make sure we take full advantage of that hour. I'll start at the far end of the panel with Aimee Carlisle, who is a senior attorney in the legal department of the criminal defense practice at the Bronx Defenders, a holistic public defense provider, excuse me. Seated next to her right, is Stephen Wu, who is the Chief of Appeals of the Manhattan District Attorney's Office. He's been in that role since March of this year. Right? That's right. Seated to his right is State Senator Zellnor Myrie. He has served in the State Senate since 2019, representing the 20th State Senate District, which includes parts of Brooklyn. And seated to my immediate left is Alvin Bragg, who is New York County District Attorney. He assumed that role in 2021 and became the first African-American and person of color to serve in that office in this city's history. So welcome to our panelists. Let's dive right on in. So I guess I first want to have you all help us understand how you see the relationship between the Second Amendment, civil rights, racial justice, guns, law enforcement, from your various perspectives. I know it's a big and broad question, but I feel like it helps us kind of frame this larger conversation. So with that question on the table, Aimee, why don't we start with you?
I was gonna let someone else start by answering. I think it's a complicated question, but the common thread to really understanding how we got to where we are today is that we have a long history of white supremacy in this country, right? We've never actually reconciled with that. And so obviously we know that the Second Amendment did not create the right to self-defense, right? It codified a right that already existed, but that only existed for generally white men. And when the Second Amendment was created, it said that people had the right to keep and bear arms, but generally did not extend that right to everybody in this country. And that Black and Indigenous people could not enjoy that right in the same way as white men. Ultimately, our attraction to enslaving human beings resulted in a civil war. That's how significant the problem was. And the Reconstruction Congress, when allowing states that seceded to rejoin the Union, said that you have to rejoin, but you can only rejoin if you agree that you're going to treat Black people, marginalized people, in the same way that we treat everyone else, right? And so you had to extend these rights of citizenship to everyone. And that's why it's very important to talk about the Second Amendment in the context of the 14th Amendment, because that's what actually makes it enforceable against the states and what extends that right to everybody. Unfortunately, because like I said, we never reconciled with our history of white supremacy, that right was not actually extended to everyone. And so states resisted what the Reconstruction Congress was trying to do. In some states, it happened by statute, right, by passing laws like the Sullivan Law here in New York. In some states, it just happened by culture, right? You didn't need a law in the books to say that Black people couldn't act the same way that white people could. In other states, it happened a little bit later, right? In California, the Mulford Act, which is their equivalent to the Sullivan Law was passed specifically because Black Panthers were exercising their Second Amendment rights and openly carrying. And so the laws that we have on the books today in states that don't actually protect the Second Amendment right for people very much have discriminatory intents and histories and impacts. And so today we, here in New York, which is where I practice, we have a mechanism that says, the Second Amendment is a right, but it's not something that can be enjoyed by everyone. And if you violate the law, if you possess a firearm without a license, right, and Bruen, we all know, was about how do you actually get a license, which is essentially impossible. But if you exercise that right without a license, you will be subject to felony prosecution, right? And that means if the gun is loaded, right, and New York has a very interesting way of defining what a firearm is and how that firearm is loaded or not. But you're looking at a 3.5 year minimum prison sentence with a maximum of 15 years. That's for someone with no record. They're looking at mandatory minimum prison time. If you have a record, depending on your record, that can increase to 5 years as a mandatory minimum. So all this to say is that the common thread is that we live in a country that's just not comfortable, I think, with Black people owning firearms. We live in a country that kind of tries to erase its history of Black and Indigenous people resisting their oppression, that wants to rewrite history in a way that's not accurate. And the reality that we see here today is that, unfortunately, despite what the Constitution says, people are very severely punished for exercising a right that should be enjoyed by every citizen in this country. And I'm sure we're going to talk about it more, but the reality is that people are going to prison in New York City and New York State for doing something that you can do in half the country without getting permission from the government, without showing that you have a specialized right. And I don't think that's constitutional, and I don't think it's right.
Great, thank you, Aimee. DA Bragg.
Well, we're going to go in order.
I gotta switch it up. I gotta keep you on your toes.
Just trying to process that. So I will maybe be, well, not maybe, will be less academic and a little more sort of just share with you my evening last night. Because you were talking, I think about these issues, as being both the sort of trauma from the enforcement being felt most in Black communities, but also that's where when you look at the data, that's where the gun violence is most prevalent. So last night, I was at the precinct council for the 32nd precinct, which is 135th Street, which happens to be the precinct I grew up in. And the richness of these community meetings. I know the senator's been in a lot, so you get a whole spectrum of issues. And in one meeting, you heard sort of both the enforcement work. Let's talk about these guns on the street. Talking a lot about sort of what they're doing in the community in terms of sort of the effect on the street level and sort of the quality of life. People, there was a very significant shooting around the corner from where I was. And they talked about that, his name's Darius Lee, who was shot and killed, and his family, and talking about how we need to support them. But then also talking about the over-enforcement and the impact that has had on the community over the years. And I've sort of been at the intersection of both. Grew up around the corner from where I was yesterday. I've been over-policed, also been shot at, and had a AR pointed at me. And as district attorney, really trying to sort of think both of those through. So we are, won't surprise anyone, we are enforcing, our state's stringent gun laws, trying to use our discretion to focus on sort of the drivers of violence, people who are doing the most violence. And I think that is something that's important, in particular, sort of in the communities I grew up in the communities that we're seeing a higher incidents of, particularly I would say the shootings, not talking about the possession, but the shootings, which are my principal concern. But then also, I talked about the work that we're doing investing in communities, because I think that's as important as our enforcement work. So the shooting that was talked about last night, we talked about how we're sort of taking that space over. So it's underinvested park, there's no lighting. It's a place that was in some ways screaming out for something bad to happen. And so we talked about the work that we're doing, particularly in Harlem and East Harlem, with grants we provided to youth who are beautifying areas that were marred by gun violence, and working kind of with cure violence folks. So for example, something that we did that really hasn't been done before, we finished a gun enforcement investigation where we charge folks who, I believe needed to be charged. We're doing a lot of harm in the community. And then there were folks for whom we didn't think we should charge. They sort of said, the culpability is not there. And I think traditionally that would have been the end of a prosecutor's role. We would have said, but I knew we were going to see those people in a couple of years if we did nothing. And so we took the step of connecting them with our community partners. And I was at a meeting, kind of like the meeting last night, shortly after that, and one came up to me and was like, this has been transformative. We've been able to, outside of the system, reach the folks who, and they sort of agree with our assessment, that were really in need, but the need wasn't, for prosecution at that moment. So I think it's complex. I think we need both the enforcement and the investments, and sort of my job, Stephen's job, is to sort of figure out which tool in the toolkit to use.
Thank you. Senator Myrie.
Yeah, so firstly, good morning, everyone. Good to be on this panel. I grew up in Flatbush, Brooklyn, and Crown Heights. Still live in Flatbush, for any people in Brooklyn in the house. And I grew up in a household where my mom told me that I couldn't play with water guns. And I'm not talking about the water guns that are more popular now. They're like water pellets. Classic Super Soaker 3000. My mom said, you can't have that because of what was going on in the neighborhood and what was going on around us. So it's just a complicated issue, particularly the political imperatives for us to act and respond when people see something happening in the national narrative. And much like the DA, we go to a lot of meetings. I have constituents come up to me, ask me, what are you doing to keep the street safe? And I think that the notion that the Second Amendment should encourage unfettered possession is something that is very hard to communicate to the community and makes it difficult politically. Now, that's not to say that we don't do those things. You asked about how we view civil rights and how that interplays with the Second Amendment. I've been a huge proponent of reforms to our criminal legal system that have not been popular in a bunch of pockets in my district. And I've received a lot of flack from that. I've had people write op-eds, do all sorts of other things. My friend here has also gotten some stuff. But I think it's important to still advance justice and what is right in the civil rights context. But there is a tension between public safety and upholding the constitutional right to bear arms. And it's one that, frankly, I don't have the perfect answer to. But I think that the legislature is much better positioned to be making these calls than the Supreme Court of the United States, completely removed from any political accountability whatsoever, as opposed to legislatures that have to renew our contracts with the people every 2 years.
Chief Wu.
So back on the enforcement side of things, as DA Bragg said, one thing I'll comment on in terms of the concrete consequences of these rulings is, the DA's office intersects with the criminal justice system in very specific ways, right? We're not always there when the crime happens. We're not there when the police respond. But one thing we do see is the aftermath of those crimes. And what we often see are situations where firearms are obviously facilitating some other crime, or where a situation is made much worse because a firearm has been present. And there are situations where the crime is pretty bad, and you worry or you wonder about how much worse things could have been if firearms were more freely available. And I think those are the sort of questions that keep us up at night. And I think that's a reality, even if you credit all the other problems with the criminal justice system, including a really unfortunate racial history and potentially uneven enforcement across different communities. And that is one of the things that is driving sort of our approach to the gun problem in the DA's office. The other thing I will say is, I think there's potentially a mismatch between the concerns about the scope of the Second Amendment and freeing up people to purchase firearms or obtain firearms more easily, and the problems that my colleague has identified in the communities. And I don't know if the best approach to something like the racial inequities in policing or even in criminal enforcement are best served by the opening up of the floodgates of firearms in the community. These are, it's a big complex problem on one side, but at the other side is a solution that potentially has ripple effects that impact the very communities that people are trying to serve. So that's sort of the other side of the perspective from our office.
DA Bragg, I'm curious if you can tell us or provide for us a sense of how Bruen changed the landscape for you and for your office, given the focus of your work. What do you expect the effects to be on gun possession in New York City with respect to Bruen?
So, look, I mean, I agree with the senator. I would love for him and his colleagues to be handling this, and we support the measures they took post Bruen, which are going to, blunt some of the effects of it. It's a decision that's going to make it harder for us to do our job in terms of gun safety in Manhattan and in the city. In the short term, with that said, it is our biggest issue is the guns that aren't licensed, right? I mean, we are, the overwhelming, majority of cases on our docket, and I think this will be true for the near and medium future, are unlicensed guns. And so what we've been doing a lot of in the short term is a lot of education, because there's a lot of misinformation to let people know, look, if you had a gun, in December, you read the paper that the Supreme Court did something, it didn't magically become lawful. That is an unlicensed, unlawful gun. We've been saying that in a lot of meetings, community meetings, business groups, people, just a lot of confusion. So in the short term, I think we'll continue to sort of, be focused there. It does, give rise to, a bunch of issues. I think particularly, we'll see more people with guns, and I think that has real safety concerns. I think the permitting, we'll see what happens. My guess is there'll probably be more licenses and permits upstate, and so we'll sort of be dealing with a lot of, particularly in Manhattan, day trips and people coming in, and I know we'll probably get into it a little bit later, but the new state law sort of areas that are restricted, where even if you have a license, you can't go through that. If you get a New York City license, the plan is to have people be trained on that. So in addition to signage, sort of where you can't take even your licensed gun, but the folks who are coming from somewhere else with a valid New York State permit. So those are kind of questions sort of we're thinking about. And then, I think further out in time, I've talked with law enforcement in other states, what does it do to sort of the street stop, right? Right now, if you got a gun in New York City, that's going to give you cause, right, to affect a stop. We're going to assume that gun is not licensed. I think that's a very safe assumption. Over time, does that change? Does the legal analysis change? But I think right now, immediately, we're still focused on our kind of illegal gun trafficking work as sort of the driver of violence, while we're trying to put in place safeguards and think about how we'll enforce, the cases that are where people with licenses that are in places where they're not allowed under state law to be as of September.
Attorney Carlisle, how do you think Bruen's going to change the landscape for your work, and what effects do you expect it to have on gun possession?
I think that Bruen has the potential to change things kind of drastically, but the problem right now is that New York judges aren't following Bruen and its holdings. And I just want to back up a little bit, because I think there needs to be a conversation about gun violence, but that's not necessarily what Bruen is about. And what I'm talking about is the fact that in New York City and in New York State, it is a C-level violent felony to carry a loaded firearm and not use it, right? So if you never shoot anyone, if you're walking down the street with a gun in your fanny pack, nobody knows it's there, but the cops stop you because you're a black man with a fanny pack, they frisk you and they recover a firearm, you are looking at a 3.5 mandatory minimum prison time. If the gun's not loaded, but you have ammo in your backpack, then it's loaded under New York law and you're going to prison, right? So if you're never using the gun, you are still looking at mandatory prison. And I think that we are really in the midst of a very significant human rights crisis because of this. It's something that we all need to talk about. And not only talk about how in New York we seriously penalize people in that way for allegedly possessing a firearm, but because of New York law, our dragnet is so broad that we're actually getting more people caught up in that who aren't even intending to exercise a Second Amendment right. So New York has all of these constructive possession presumptions such that if you're in a car and a firearm is found in the car, DA Bragg will charge all 5 people in the car with possession of the same firearm, and everybody's looking at that same mandatory minimum, even if, like in my cases, one person confesses and says the gun is mine, no one else knew it was there, all of my clients are going to be in on bail, right? If a gun is found in a building, that everybody who's in that building, like an apartment unit or something like that, can be charged with constructive possession of the same firearm. I once had a case where 18 teenagers were charged with possession of one firearm. And even though I was able to get my clients dismissed, their lives were ruined in the weeks that it took for that to happen. What we're talking about is sending people to Rikers Island, which is the most dangerous jail in the country, and having them sit there while they try to pay their way out. We know, I think there have been photographs of what's happening at Rikers Island recently, right, which is people are sitting in their own feces, they can't access medical care, they can't get the mental health services that they need, all because they're charged with possession of a firearm and not ever using it. And yes, of course, there are people who use their firearms. Where I practice in the Bronx, they're usually charged with attempted murder, right? So it's a totally separate charge, separate kind of sentence, separate reality. But what we're talking about and what Bruen is really about is the fact that the Constitution says something and states like New York are resisting that mandate of the text. I think Bruen is also very clear, and the Supreme Court has been clear in earlier cases, right, that this is a private individual's right to self-defense, to carry a firearm in self-defense. And I think at this moment, Bruen has not changed anything in New York because New York judges aren't following the law. I've seen cases where prosecutors have filed briefs saying that there's only one holding in Bruen, and that holding was that the proper cause standard in New York is not constitutional. That's just not realistic, and that's not what Bruen says. Bruen has additional holdings that I'm sure you all are familiar with, but the reality is that New York judges are just ignoring what the Supreme Court has said. And I think there are questions about, should the Supreme Court be the proper forum for us to address all of these things? Perhaps not, but the reality is that the Supreme Court said that it's the government burden to show that any infringement upon the Second Amendment right has a historical analog. And there's no historical analog for forcing people to go to prison for 3.5 to 15 years if they have no record, 5-year minimum if they do, just for carrying a firearm and never using it. Thankfully, some judges in other states like California and Texas are actually following Bruen. I've seen at least 2 cases where judges have dismissed criminal prosecutions by following that historical tradition test, but in New York, no one's doing it yet.
So I actually want to stick with that that set of questions for a moment and actually ask Chief Wu what your kind of response is to those legal arguments. And I know defenders across the city have filed motions trying to get these cases dismissed based on the holding in Bruen. And judges, as Attorney Carlisle has said, have rejected those arguments out of hand. And so I'm kind of curious what your response is to those arguments.
Yeah, so we've opposed a lot of these arguments. I will say I do think Bruen has made the litigation world very interesting over guns. It's perfectly right for defenders to raise these arguments in opposition to these gun charges. And we've largely been successful, we and the rest of our colleagues in the city, in resisting them. But there's an added element of uncertainty here, and that's one of the things that we see our role in litigation as protecting against is potential disruption of our attempts to keep communities safe through this type of litigation. I do think one important reason that courts have been rejecting these challenges in these cases is not so much, I think, because of disagreement with where the Supreme Court has gone, although that might be there, deep in their heart somewhere, but because what we are seeing in a lot of these factual situations are individuals with guns who we think would not be entitled to have the guns even under Bruen's holding, or are possessing the guns during the commission of other crimes or obviously to facilitate other crimes, which is also something that Bruen typically doesn't, I think, would not support here. As DA Bragg said, unlicensed possession is the biggest problem in our city, and many of the defendants who we're facing are individuals with past felony convictions, including violent felony convictions, and who wouldn't, Bruen did not disrupt the state's ability to come in and say, we at least need to be able to tell who is possessing firearms here, and we can adopt criteria to ensure that only responsible citizens are able to possess guns in the first instance. And then on the other side of it, I understand New York law does not currently require us in every possession case to show that the gun might be used with the intent to commit some sort of unlawful conduct. But that is a lot of the cases that we see. It doesn't show up maybe in the criminal docket because it's not a required element of the crime. But part of what goes into our charging decisions is also, whether or not the gun is there as part of a larger drug operation, right? Whether it was part of an attempted assault. And those facts are present in these cases, even if they're not required to be proven under New York law. And this is another situation where I think judges see the reality of the facts coming before them and understand that these are situations where the presence of a firearm or in some cases even the use of a firearm really inflames what happens and causes greater risk to the people involved.
Senator Myrie, I'm curious if you could tell us how the legislature responded to Bruen and kind of give us kind of your thoughts about that response.
Sure, and let me, before I get there, say that I agree with Aimee. I actually sponsored a bill to end all mandatory minimums. I think there is a case to be made that they offend our notions of fairness and justice and don't allow for the courts to look at individuals and individual fact patterns as it relates to sentencing. And so I think that we should eliminate all mandatory minimums. But on Bruen, part of the difficulty with the test that Justice Thomas laid out was the onus that it puts on the legislatures to become PhDs in 18th and 19th century gun regulatory frameworks. If we are tasked with doing things that are supposed to be a historical analog, when we were drafting, we looked at 18th and 19th century gun regulations, but we also looked to the other states. Albeit in a footnote, the court did essentially uphold the regimes of 42 other states, and so we looked to those other 42 states as it related to sensitive locations, not the application process. And we looked to those 42 states and took what we thought could uphold or would be upheld before a court. Now that, of course, we've been sued already, the state, to stop it, and the federal district court judge, in his opinion, charitable description of it, said that all of this is unconstitutional, but we still have to let it go because you don't have standing, right? And in his arguments, he didn't really address Justice Thomas's test, didn't do any of that, and I think that in and of itself presents the difficulty in this test, that the courts, the legislatures, we're not, New York, it wasn't New York law, but we will not be the last legislature to confront this, so it's made it very difficult. But in short, we basically focused on the who and the where. So who can now get a concealed carry permit and where can they do it? And then we tried as best as we could to meet what the Supreme Court laid out for us.
And can you tell us a little bit about I know that you've also been involved in sponsored the Community Violence Intervention Act, so I'm kind of curious if you could tell us a little bit about that piece of legislation.
Yeah, I think one of we're all trying to talk to it and talk around it. The solutions to gun violence, I think, are both, we have to think about what stops things right now in the immediate and the long term. The Community Violence Intervention Act was a bill that I sponsored that was in the long-term category. It invests in community and hospital-based intervention and prevention programs, requires the state of New York to invest $10 million of that every single year. And the reason why that was important, because in the legislative findings, I made sure to include that the state would be declaring gun violence a public health crisis, such that the approach is not just legal one, but one that requires us to adopt a public health approach to solving it. And so just this year, in the first year that it went into effect, $7 million already has been awarded to groups on the ground, on the streets, doing the work, preventing, intervening, hospitals that get victims of gun violence and then wrap around the services so that they're not recidivizing or further being victimized. So we have, I don't think that this is going to be challenged by Bruen because this amended the public health law. And it's the same thing that we did on the gun liability law, where it amended the general business law. I'm trying to avoid those Second Amendment difficulties.
Got it. So, D. Bragg, I want to come to you really quickly with a couple of questions. First, I'm curious just to hear your response to what Senator Myrie laid out, this notion of eliminating mandatory minimums altogether. Because I think Attorney Carlisle made some really compelling points on that piece, as did Senator Myrie. So I'm kind of curious to get your take on that. And then I want to ask you about how your office is kind of handling gun cases before and after Bruen. So why don't we start with the first kind of concern around the mandatory minimum piece?
Can I even go a further step back to
Take
my
it.
colleague from the Bronx?
Make it happen. Go ahead.
And I want to agree with we may disagree in the application, but agree with the kind of fundamental premise on the constructive possession cases. I mean, so, my brother-in-law did more than a year in jail on the constructive possession cases, and then came to live with me afterwards. And so, I those cases I think are fundamentally challenging. It was a schoolyard fight, with, 4 just barely men, and he went to jail for more than a year for a gun that he didn't touch, certainly didn't discharge. So, we're a work in progress. We've been there since January. That's sort of a point of emphasis and something that I want to focus on. Not suggesting that we've got that done perfectly, but it's something that certainly concerns me. And the same thing with sort of the disparate impact of the searches. When Steve and I were at the Attorney General's office, something the Civil Rights Bureau did, and I oversaw that work, was study of stop and frisk. One showing efficacy issues, like only 0.1% of all stops resulted in a recovery of a firearm, and then sort of deep racial disparity. So before Bruen, and not really related to it, but more so with sort of our change of administration and also sort of discussions about policing differences, we did more training around that. And again, not to suggest that we're done with that, that we don't need to do more, but particular points of emphasis. I agree with Senator Myrie on the sort of the spirit of that. One thing he alluded to, some of the criticisms I've taken is sort of, at what points do you, affect the will of the legislature as written? And the word mandatory is in it, so that is one where we have less discretion in other places. But what we are doing is, at the charging stage, looking underneath, right? So if someone has, 2 prior convictions for what is, designated as a, violent felony, what were the facts? What led to that designation, and should we charge it differently so that we don't have, we don't end up in the mandatory box? So we have some charging flexibility, and that's something that we're thinking about. Again, it's, don't profess to say we have it to scale, but it's certainly a principle that we're kind of trying to execute in the office. And I think there may be disagreement about how that would be applied, but certainly it's something we're mindful of. And now I've forgotten the back half.
Yeah. So the back half of the question was, how your office is handling gun cases, before and after Bruen. You did provide some insights about kind of the post-Bruen world. I guess I'm kind of curious. Bruen expanded the range of scenarios in which you're likely to see folks carrying guns in New York City. I think you mentioned earlier thinking about tourists coming from other places with permits, thinking that they're able to carry a gun here. A person who carries a gun into a sensitive place without realizing that they can't have a gun in that particular place. I'm kind of curious how your office is going to respond to those types of scenarios. What do you think? What are your considerations for going into handling those types of cases?
Right. So I can definitely talk about the considerations. The obviously I've only been here since January, but I'm told that prior to January there were a number of the phenomenon that I said about sort of people coming from upstate with licenses has been around for years, with people coming from other states, Texas, Florida, other places, and then they go to Statue of Liberty, they're waiting online, and they got to check the gun, and so we've had those kind of cases, which often turn out, is that a genuine, did you come here and really just not know that it's not Texas, and analyzing that, one thing that would be different that as a consideration that we'll have to, I think it's going to be sort of case by case as we sort of develop sort of our own common law. But what do we do with someone who comes from another state with no licensing regime and has a gun? That's going to be a Class C under our law. Someone who comes from Tioga County here in New York and goes into sort of one of these locations is going to be Class E. Is that fair? So that's a consideration that we're wrestling with. I think a lot of this is going to be very fact-borne. We had a case recently with someone who was, didn't have a license, did not have a valid New York license, was from out of state, and they were trying to get on the train, with a semi-automatic weapon. So to me, also it matters location. Transit's been sort of carved out under the state law. And a lot of places have been carved out, but to me, that is our sort of bloodline. So I think that's a place that we want to that's a consideration. So the where, which sensitive location, and then the kind of gun. I mean, to me, getting on the 2 train with an AR is, I think a lot of New Yorkers' worst nightmares, one of my worst nightmares. And so I think location, type of gun, where you were issued. So the New York City training, at least the plan, is that it's going to have robust, hey, like Times Square, you can't go there, you're going to sign something. That's the plan. You get your permit in Albany, you may not have that same education, which I think is both for fairness consideration and a proof, because we're going to have to show, we have to meet CNTR requirements. So those are some of the things that we're thinking about.
Got it. Attorney Carlisle, can you talk to us a little bit about the kind of resources, energy, and effort that goes into kind of defending these types of cases? I know, and I say there's no typical gun case, but I'm just
I will, and I'll just to kind of backtrack for a moment, I will say that I think everyone should kind of look at the current law in New York, the new statute that the legislature passed in response to Bruen. I think is also, again, unconstitutional under Bruen. In order to get a license, an applicant has to give police officers all of their social media accounts and passwords for the past 3 years, right? And for some reason, the cops get to look at all of your social media history, which might include Tinder, might include Grindr. Like, I don't understand why police officers need to know that level of information about a person before they decide whether or not to give someone a license. And there's no similar regime for someone to exercise their right to vote, their right to get an abortion, their right to protest, or anything like that. Regarding gun criminalization and prosecution right now, in the Bronx where I practice, the standard offer on every gun case for someone without a criminal record is 2 years in prison, followed by 2 years of basically parole. That is the standard offer that we're negotiating against as defense attorneys. My understanding from speaking to my friends who are also public defenders in Manhattan is that's currently the standard offer in Manhattan as well. So for every single case where someone is only charged with possession, not using it in the course of a robbery, not doing anything else, we're looking at prison time. And as defense attorneys, we're trying to get our clients into programs instead. We're trying to get probation. We're trying to get maybe city jail time. And it's really an uphill battle to explain to prosecutors why our particular clients do not deserve to go to prison for possessing a firearm and not doing anything with it. And it's very challenging. And I would say, too, as a constituent of yours, Dave Bragg, that I was optimistic when you took office that there might be a change, and I'm hopeful that that will still happen, particularly in light of your experience, which I think you've talked about, and that I was definitely aware of the fact that your father, I believe, right, had an unlicensed firearm in your home when you were a child, and like he didn't use the firearm to hurt anyone. His only intent in possessing that firearm was to protect your family and for reasons of self-defense. And so I'm hoping that the standard offer in Manhattan and the Bronx will change, and that people won't be looking at prison time for possessing a firearm. One of the really big challenges of defending people in this work, again, is the way that bail interacts with these kinds of charges. So typically, if someone has no record and they're charged, again, with criminal possession of a weapon and nothing else, the prosecutors where I practice in the Bronx are asking for $100,000 bail, $150,000 bail, $200,000 bail. People cannot pay that. The Bronx is home to the poorest congressional district in the country. And so people are sitting in jail, like I said, at Rikers Island, where there's a human rights crisis, where they can't access medical care, where they're being tortured and assaulted, and they can't get out. I think one thing that's also very challenging is that in many of these cases, there are bad actors. There are police officers who are acting unlawfully, right? So I'm saying that the stop is bad. Again, I gave you a scenario earlier of someone being approached and a police officer grabbing his fanny pack and recovering a gun, right? Those stops are illegal, right? Police officers need a basis to come up and approach you and to search what you have. And in many of these cases, the police officers are not acting lawfully. But there's no test and there's no way to require police officers to act better, because prosecutors are supposed to be looking at those cases, and I don't think that they're looking at them thoroughly enough to say, like, hey, we can't actually meet our burden at a suppression hearing. We need to dismiss this case now instead of waiting for the case to go to hearings and trial 2 years later after the person's been sitting at Rikers that whole time. So it's very difficult to defend people, and like I said, the reality is that most of our clients are in jail, so they don't have access to their families, they don't have access to their attorneys, because it's hard to get to Rikers from the Bronx. And the reality is that most people are not willing to test their case to hold the government to their burden, when the reality is, again, a 3.5 mandatory minimum prison time. And I think most people here are familiar with what we call the trial tax, right? Which is that if, in most places, if you actually go to trial and lose, you will be sentenced to something higher just because you went to trial and you kind of use government resources to hold the government to their burden. So it's incredibly difficult. And I think someone mentioned earlier the things that keep us up at night. You know, the things that keep me up at night are watching police body camera in some of these cases and seeing my clients being tased, right, because someone else in a car had a gun, and listening to my client scream, and then having them sit at Rikers Island for 2 years until I can finally try to get the case to a suppression hearing and see if we can win. I think there's been a lot of talk about violence and harm, but I think that we as a society need to really think critically about the harm that's caused by sending people to jail, right, when they're presumed innocent for these kinds of charges. We need to talk about the harm to families and communities that happen, right, when we give someone a felony record and they get deported, right, and they can never come back to the United States again. I would encourage everybody to come to criminal court where you can see people being sentenced, right, see someone and their children in the courtroom crying because their dad is going away for 4 years because he possessed a firearm. One of my friends has a case in Manhattan, that person's serving a sentence right now, but they asked the Manhattan DA to just adjourn sentencing for 2 weeks so that client could go to his daughter's 6th birthday. And the Manhattan DA said no, and that person has missed his daughter's 6th birthday, 7th birthday, gonna miss the 8th birthday. And this is also harm and violence too. People's families and communities are being torn apart because of what's happening. And that's all in the backdrop of this. When I'm telling my clients and I'm trying to explain to them, why are you looking at the same kind of felony charge as the person who actually possessed the gun? What does this reality look like? This is what we're talking about, is how hard it is for people to actually vindicate their constitutional right, whether it's a Fourth Amendment right to be free from unlawful searches and seizures, when they know that they're gonna have to sit in jail for 2 years for a judge to finally say, yeah, that stop was illegal, and dismiss the charges. It's very, very difficult for people to deal with that, and it's very difficult. Most people just take a plea deal and go to prison, or take a plea deal because they don't want to face the risk of having a higher sentence at trial.
So I know we only have a few minutes left, so I want to try and do some rapid fire as best I can, and I know folks want to respond as well. So let me just start with one of the concerns that Attorney Carlisle mentioned, which is police. You know, my sense is, or my guess is, that their antennas will be up. They'll be more aggressive with this notion or thought that Bruen signaled a wave of guns coming onto the streets, right? And so, in that sense, they may be more aggressive, may stop people more often, may engage in much more conduct. I'm curious, Chief Wu, if you, and this may be a question for DA Bragg. You all decide who should answer it. But if you've provided any guidance to the NYPD about the implications of Bruen, the Fourth Amendment implications about how they should conduct themselves in terms of engaging with the public. Their sensitivity to their gun possession, I think, is going to be up, and so I'm kind of curious if that has been part of the conversations you've had with the NYPD at all, or if you've had those conversations.
So I'll start, and then if I have got. So what we did, I think I mentioned it earlier, pre-Bruen, really more because of this kind of, shift in sort of policing in the city and the deployment of I can't remember what the teams were called, but so there are going to be more stops, and so we made sure to go back and do DeBoer, which is the New York standard, and Fourth Amendment training. That wasn't related to Bruen, but more related to sort of changes in discussion of kind of policing practices. Post Bruen, I think most of our conversations have been about policy, have been about the new law. We do meet periodically kind of with the mayor's council, the deputy mayor for public safety, and the 5 district attorneys. We've talked mostly about the new law implementation, a bit about this, your question, but I don't think we've talked about training, but I'm glad you flagged it. We can raise it at our next meeting. I don't know if that's anything else, Stephen.
No, I mean, I thought I might comment a little bit on there are definitely legitimate questions about the way prosecutors, police exercise their discretion in these cases, and one of the things that DA Bragg has done is to sort of open the discussion within the office about what we do with charging decisions, our positions on bail, what sentences we seek, what offers we make, whether there should be or is a trial tax if people go to trial. And, obviously every case depends on the facts. The important thing for us, I think, is that these decisions are driven by not only questions of individual fairness in the cases in front of us, but also questions about the effect on the community and public safety. Does somebody, whether or not the law requires it, does somebody actually present a risk to public safety? If they don't, maybe that recommends a different approach from us, including, we have a new division that looks actively into non-incarceration alternatives when we don't have to put somebody into prison. But that's sort of how we've been approaching these individual cases. One of the criticisms of Bruen that I think is a legitimate one is that this type of factor is not present in the analysis about whether a new or present gun restriction is a constitutional one, right? That's one of the big changes the Supreme Court made, was in rejecting the idea of a state interest, public interest, government interest, and saying, not just that we have to do this sort of weird analysis of like dusting off ancient sources, right, including and trying to analogize county fairs in medieval England to the New York City subway today, but also disregarding in these cases what the actual practical impact of striking down a gun law would be, or requiring a certain approach to guns would be. So I think that's one area where, as I was saying in the beginning, we might have a shared interest in making sure that public safety and individual fairness are accommodated. And one of the open questions going forward is to what extent Bruen still allows us to engage in that inquiry when it comes to gun restrictions and licensing.
And I'm glad, Steve, you mentioned alternatives to incarceration. So we did, it goes beyond sort of our gun dockets as all felonies. We've kind of stood up a new division on par with our sort of trial division and litigation division to promote alternatives to incarceration and to promote it particularly early in cases, so people are not spending their time in Rikers. And so this is not a gun statistic, it's broader than that, but sort of on the year to date, the kind of use of referrals to felony alternatives to incarceration is up 250% in the office, which is something I'm very proud of. I don't know what percentage of that is gun cases. I do know a significant number of our gun cases do end with a non-carceral outcome. I don't have but just want to add those 2 data points.
Senator Myrie, one of the pieces of legislation you mentioned earlier, the gun industry liability law, I'm kind of curious if you can tell us what that law is about, and in telling us and describing for us that law, what your sense is of the kind of civil solution for some of these challenges.
Yeah, so I, again, back to the short-term, long-term solution framework, I have never been, and with much respect to the 2 gentlemen next to me, I've never felt that our gun violence problem was one that was best solved by us going after the shooters right now. We have to do that, I think, in some way to protect people, but most of the guns that come into this state are not made in this state and not sold in this state. The overwhelming majority come from other jurisdictions, and because of a federal law passed in 2006, the Protection of Lawful Commerce in Arms Act, they can't be sued. The gun industry can't be sued. Gun retailers can't be sued. Even if people are coming in repeatedly, making purchases that suggest that they're going to traffic, even if they're leaving their doors open, even if they're burglarized 10 times in a row, and they have a direct connection to the streets that end up in Brownsville and Crown Heights and in the Bronx, they cannot be held accountable. And so I started looking through the case law on this to see how we could somehow get a foothold. And the exception in that federal law, the predicate exception, states that if they violate a state gun regulation law, then they can be held accountable and held liable. So you just got to make the state law, and that's what we did in 2021, and it was signed into law in July. The gun industry sued us, December of last year, and in May of this year, the Northern District of New York upheld the law, rejected all of the gun industry's arguments, every single one, and we've now seen California adopt a similar law. Delaware has adopted a similar law, as has our good friends across the Hudson in New Jersey. So I think this is a really important mechanism. They have been very guarded, they being the gun industry, on allowing people to bring them into court because of what discovery might produce and because of what the damages may be. And I believe that just like we've done in the tobacco context, the opioid context, in the car industry, we wouldn't have safety bags if it wasn't for litigation. We've done this in many other contexts, and in the whole ecosystem of corporate civil liability, there is only one industry that stands alone, largely immunized, and that's the gun industry. And I think that our law is going to begin to change that.
So I think we probably have to stop there, unfortunately. I did want to ask you all to maybe have no, we had to stop. Huh? We'll do one more. Okay, this maybe we just go down the line. Just the last question: if we take prisons and jails and policing off the table, think about solutions to these problems, what would you propose? Start with DA Bragg.
So I'll tell you what we're doing, and I would take it to scale. So we've got we invested $8 million in a trauma center in East Harlem. In East Harlem, we also have community navigators just going out and connecting people, with healthcare and other services. In Central Harlem, we have a Harlem hub where we've got co-located Department of Sanitation, Department of Buildings, dealing with scaffolding issues, our city hospital service. We're sending out basically in street teams to meet the underlying needs. I would continue kind of the gun grants we've done, where we invested directly in our youth. So I agree. I mean, I'm in this role and we're doing enforcement. I think that is essential, but I agree with that kind of short-term, long-term dichotomy, and that those investments, some of which can be short-term. I mean, so the investments we did this summer, we did those in August. I was back, in a gym in Harlem with the youth who got that money, and the mentor who runs that program was like, that money for August was transformative. And obviously this is lots of factors going into it, but shootings and homicides are down year to date. And I think those kind of investments really matter, and it's not a traditional part of the role, but sort of one that I think we can continue to do. But we obviously need we need the appropriations, we need the other folks who are more that's in their bailiwick. And the one issue I would lift up, which I don't think we've said directly, but is the mental health component, particularly just that investment. It's not just guns, but that affects so much of the crime we're seeing. And so we're in the process of thinking about how we can sort of do some short-term investments and sort of pilot some things, which then we can take to our colleagues in Albany and say, or in City Hall, and say, can you fund this and baseline it in the budget?
Thank you, Senator Brown.
Yeah, just say housing, healthcare, and education. If we invest in all of those, and if your outcomes in all three of those areas were not determined by the zip code that you live in, I think a lot less people, a significantly less amount of people would be resorting to the things that get them involved in the criminal justice system.
Thank you. Chief Wu.
Yeah, and I'll echo what Alvin said. I mean, we're here at the enforcement side, which is often too late to change anything in terms of like the root causes of these problems. We often see these sort of vicious cycles where people get guns because other people have guns. They see it around. It's easy to get them from all over the country. In my ideal world, like the problem would be approached in this sort of more holistic way, where you sort of go further down the chain. You worry about people we don't see, and how guns get to the city, and we find some way to ensure at the tail end, right, that the spigot of licensed guns coming into the city doesn't continue to flow. I think that's an important part of this, and that gives us some time and breathing space to address other issues in the system.
Attorney Carlisle.
Definitely investing in communities, housing, healthcare, but I also think employment, right? People need to actually have legitimate ways to support their families, particularly since so many of them are violent felons already because of these laws. And I think that we just, like I started off by saying, still need to reconcile with our history of white supremacy, because if we don't, right, the solution is going to morph into something that just perpetuates that all over again.
Thank you. Well, join me in thanking our wonderful panel.